Okay, I'm going to talk now about Michael H. versus Gerald D. The reason this case really deserves its own short video is that it's one of the best illustrations in your reading of the importance of issue framing. So we're going to talk about that primarily, but obviously the rest of the case as well, and what it means substantively. So in this case, Gerald D. Is the aggrieved husband, right? This is a guy who's having a really rough year. First, Gerald D. found out that his wife was cheating on him. Then he found out that she was pregnant, and then he found out that biologically the child was not his. Instead, the child biologically is the child of Michael H. In this case, both, I think I've mentioned this to you before, it's a remarkable kind of a fact pattern if you're a family court judge looking at this, because both of the men in the picture here behaved as typically, in your average case, neither one of them would have, i.e. the husband, Gerald D., decided he was going to stick around, try to save the marriage, try to salvage the family, and he vowed that he would raise the child as his own, even though biologically it was not his. So he's not doing what most people do in that circumstance, which is file for divorce, right, and get out of the picture. Michael H. is also not behaving as most of the people in his position behave. Most of the people in his position are on the next bus to New Mexico, but Michael H. decides that he is going to, he too is going to try to stay involved in the child's life. He regards the child as his own since he's the biological father, and he wants to have a relationship and contribute to the upbringing of the child. Now, Michael H.'s problem is a California statute which indulges a presumption that if there's a paternity dispute between two men, and one of the men happens to be married to the mother, the automatic presumption is that the child is the child of the husband. Now, of course, this law was adopted back in the days before we had DNA tests and all that, and people were basically saying, does the kid look like the mailman, that type of thing. That's factually where we're at. The reason it's a constitutional case is because there's a challenge to the California statute, right? I mean, remember that. You don't have a constitutional case unless you have state action. So this is not a private paternity dispute. This is a challenge to the California law, right? The law that creates this presumption of paternity on the part of the husband, right, of the mother. So, issue framing wise, obviously Michael H. here is going to go pretty broad and flowery here. Michael H. is going to allege that he has a fundamental unenumerated right that is violated by the California statute, a statute, again, from his perspective, that awards paternity rights to the non-biological father of the child, and then he's going to claim in violation of his right to be a parent and to have a relationship with his child. California is a state, so these are unenumerated rights, the whole drill. Ninth Amendment says we have unenumerated rights, 10th Amendment says sphere of life. Right, the argument here is going to be that includes my relationship with my children. That's none of the government's business. The government can't interfere with that. And because California is a state, you cite the 14th Amendment as well. As I mentioned, then you get to this issue of framing the question. And again, Michael H., the lawyers for Michael H., they do a good job. They try, but they don't succeed here. Right, their argument is broadly that a biological parent has a fundamental constitutionally protected right, a liberty interest, in maintaining a relationship with his or her child without the government's interference. So you see that's nice, broad, there's nothing narrow about it. Now, I'm not giving you the narrow definition quite yet because Justice Scalia is the one, right, who lays that out for us. Now, again, Justice Scalia is the one who writes the opinion. The most important, I hate to read at you, but again, that's one of the reasons I wanted to pick this case out, because some of the language in here is really important. So I would direct your attention to Note 6, the court's note, Note 6, in Michael H. versus Gerald D. Now, part of the backdrop of this, you have to understand that Justice Scalia is not a fan of substantive due process, right? He often puts that in air quotes, or used to when he was still with us. And so he regards this whole idea of substantive due process as a departure from the text of the Constitution. As a social conservative, a traditionalist, he was not a big fan of kind of newfangled ideas about personal liberty and all that. He saw a robust role for the state in regulating morals and what he would have regarded as public morals. So you have to understand he's coming at it from that perspective. Now that being the case, what kind of if this was a Canvas Studio video, I'd ask you, I'd put a little quiz question in here. If he is not a big fan of this whole area of law, substantive due process, and recognizing new privacy rights, then is he going to indulge really broad, flowery descriptions of these rights, right? The broad, flowery frames in these cases, or is he going to go really narrow? The answer, of course, if you have a narrow view of substantive due process and you don't want to be finding all kinds of new broad, flowery rights, is that you're going to take a very narrow, specific, particular view of framing these supposed rights. So, note 6. I'm looking at the second paragraph. Now he's in a fight here with Justice Brennan, who dissents and says, this is an antiquated statute. We should recognize this new right. This person is doing the responsible thing. He wants to have a relationship with his child. We don't live in the Stone Ages anymore. We have now DNA tests. We can figure out who the biological father is. We don't have to be relying on these presumptions. You get all that, right? So these two are in a fight, Justice Scalia versus Justice Brennan. So Justice Brennan wants to broadly define the right as the right to parenthood. Here is Justice Scalia's response. So look how important it is how you frame the issue. And he's got the majority. We do not understand why, having rejected our focus upon the social tradition regarding the natural father's rights vis-a-vis a child whose mother is married to another man. Look at how he's framing this already, right? He's talking about somebody, right, whose mother is a child whose mother is married to another man. He's already painting the picture of an interloper, right, injecting himself into somebody else's family. Justice Brennan would choose to focus instead upon parenthood. He's saying here you went too broad. Why not the relevant category not be even more general? Perhaps family relationships or personal relationships or even emotional attachments in general, right? He's moving in the direction of why don't you just say love? Too broad. He says, wait. He's arguing that once you move away from the most specific possible framing of the right, there is no logical stopping point. Now, I mean, we can debate about that. Certainly it's a debatable proposition. I mean, most judges, or I shouldn't say most, many judges would argue, that you can find a reasonable framing of the issue without being either too specific or too general. But I just want you to get the debate here, right? Scalia is saying you're going too general, and once you start going general, there's no principled place, right, to stop. The dissent has no basis for the level of generality it would select. We do. We refer to the most specific level at which the most specific level at which the relevant tradition protecting or denying protection to the asserted right can be identified. Now here we go. He's going to identify his framing of the right. If, for example, there were no societal tradition either way regarding the rights of the natural father of a child adulterously conceived. Do you see what he just said? The rights of the natural father of a child adulterously conceived. That is his framing of the issue. Okay? So, if the issue here was the right of a responsible adult to enjoy a relationship with his or her child, the right of parenthood, then Michael H. probably would have won. But if the issue here is what rights traditionally, right, under our history, belong to an adulterer, right, an adulterous fornicator who's invading another man's family, if that's the way you frame the issue, then obviously you know how this is going to come out. Now, Here's the picture that Justice Scalia is painting here, and again, he has the majority in tow. There's another principle that comes out of this case, in addition to the principle, right, and watch for Justice Kavanaugh, again, has said he's a big fan of this approach of very narrow definitions of rights. So I think the court is still pretty much right in that territory. So in addition to the principle that this court likely would lean on narrow definitions or framing of the right at issue, there's also the principle of the unitary family. Scalia says, and the court says, there is a protected interest involved in cases like this. But he's saying to Michael H., but you don't understand what that interest is. I don't know if you've ever seen the movie Meet the Fockers. I said Fockers with an O, right? Very funny movie where Robert De Niro plays a retired CIA agent, semi-retired, I suppose. And his son-in-law is trying to get into the family, right? His would-be son-in-law, rather, right, who's courting his daughter, is meeting the family, and Robert De Niro's character tells the would-be son-in-law, right, that his mission is to get into Robert De Niro's circle of trust, right? There's a circle of trust, and you need to get in the circle of trust, right? And that's not an easy thing to do. I always think about this case as Justice Scalia drawing a circle like that, right, called the circle of trust. And the circle of trust, in legal terms, he calls the unitary family. So think about the unitary family. In other words, family unit. That is, he says, a constitutionally protected interest. The problem with Michael H., Scalia says, is here we have our circle of trust called the unitary family, and you, Michael H., are outside the circle of trust, right? The circle of trust is the protected unit, is the constitutionally protected unit, right? The unitary family. By the way, please do not put circle of trust on an exam. Do not put circle of trust on the bar exam. They won't know what you're talking about. But I hope you get the imagery here, right? There's this unit, and Michael H. is outside the unit, and therefore Michael H. has no fundamental right at stake in this case. Therefore, California's law survives if it's rational. In a paternity dispute, it's a legitimate state interest to save judicial time and resources in resolving a paternity dispute. That may not be a compelling interest, but it's a legitimate interest, right? To save time and resources, figuring this out, don't have to have a hearing. Is a presumption a rational way to save ourselves all this hassle and to save ourselves all these resources? Yes, it is. It's a rational way to do that. So this law probably would not, almost certainly would not have survived strict scrutiny, but it doesn't have to, because Michael H. has no fundamental right at issue. If anybody has a fundamental right at issue, it would be Gerald D. But Gerald D., of course, is not the one filing the lawsuit. So, number one, appreciate how issue framing, right, and how to argue these cases. Number two, unitary family goes on the list of protected interests. You ask what is that? I mean, the court at the time, right, this is before Obergefell and same-sex marriage, so I mean the court at the time by unitary family would have meant a married man and woman and their kids and their German Shepherd or Golden Retriever and whatever 2.5 cars in the driveway. So that's a very traditional view, right, of the family unit. So we'll see where the court heads from here, but that pretty much is a wrap on fundamental rights. Now we still have to talk about the issue, I keep mentioning sexual orientation. The court deals with that differently per Justice Kennedy, but that is a wrap on fundamental rights. So stay well and stay tuned.